We are live. All right, welcome to the House Judiciary Committee this Wednesday morning, March 11th. We're turning our attention to H 606. A little bit of an introduction. So this is an amendment. We usually would be looking at the bill as introduced, but given the short time that we have before crossover, given the limited time that we have to address this particular bill, I'm having Eric, our legislative counsel, go over a draft amendment, a proposed amendment from me that does a couple things, and Eric will get into this a little bit further. But we've received a lot of emails and a lot of concern, and I've had discussions with Chris Bradley and others regarding some of the sections that seem problematic and may have something to them, but really would take a lot more time to get right. So I've struck from this amendment, strikes section related to industry accountability, and also strikes language related to machine guns, which frankly are heavily regulated by the federal government. So felt that was okay to do that. So it's really simplified this bill a lot, and it has three main components that our legislative counsel will go over, and we'll have testimony on those parts. We've had a lot of requests, a lot of emails on this from all sides, and the focus has been on those sections that have been taken out, but not entirely. My intention is at this point not to have actually a public hearing on that, but I'm going to be having all those emails put into our public record so that they will be there. They'll be considered as written testimony, so everybody's voices will be heard. And I have been receiving a lot of emails on this, and I appreciate the attention to this. So with that, I will turn it over to Eric. Thank you for being here, Eric.
You bet. Good morning, everybody.
Good morning.
Eric Fitzpatrick with the Office of Legislative Counsel here this morning, as the chair said, to walk the committee through a proposed amendment to H 606. H 606 being an act relating to firearms procedures. So as the chair said, the proposed amendment that you're looking at in front of you essentially strikes a couple of sections from the bill as it was introduced and rewrites another section. So in the big picture, there's strikes a couple of sections, rewrites another one. I'll get into more detail of that as I go through it, but that kind of gives you a flavor of it, the difference before we look at the substance. And there's a number of different sections, as you can sort of glean from the title of the bill, an act relating to firearms procedures, that there's a few different things going on here. It's not any one particular thing, but the sort of common thread is that they're related to firearms. Having said that, then let's take a look at the different sections so the committee can understand what the different proposals are in the amendment. Section 1, so are we all looking at the right amendment, I guess? It's H 606 proposed by Rep. Lalonde, and it should be dated March 9th, 2:04 p.m. Is that correct?
Yep.
All right, good. So in that version of it, you look at section 1, page 1. This was also section 1 of the bill as introduced, so it's unchanged. And the proposal here, and actually, now that I think of it, this is on the wall. Yes, H19 up there on the wall. So this just takes a bill that has been introduced and referred to this committee, H19, introduced by Reps Donahue, Burdett, and Gosselin, and just puts that into this proposed amendment. And what this section does is, just a moment of background. I'm sure, as this committee knows, having dealt with property crimes so much over the years, generally speaking, with respect to property crimes, the difference between a misdemeanor and a felony depends upon the monetary value of the property. Remember what that number is? 900. Thank you. Such a weird number. It's always it's strange to remember. Legislative compromise many years ago between 750 and 1,000 landed on 900. So if, generally speaking, with property crimes, if the amount stolen, embezzled, whatever it is more than $900, it's a felony. If it's less or $900 or less, it's a misdemeanor. And that exists currently with respect to all the property crime statutes, but this one that you're looking at right now in section 1, grand larceny. The proposal, though, is to, if the property stolen is a firearm, to have it always be a felony. That's the proposal. So you see that value of the property would not be relevant anymore. at least with respect to firearms in particular. So if you look at the language, line 16 through 18, actually start at line 15, because that describes the existing state of the law, which I just mentioned. Generally speaking, depends on whether or not the firearm is, like with any other property, is $900 in value or more. But if the stolen property is a firearm, the proposal is that it would be grand larceny, which means it's a felony.
I think that's Zach has a question.
Yes.
Thank you, Chair. Do we do that with any other products, Eric?
That are specific to a particular product, you mean, that sort of, that would be the.
Instant felony.
Say it again, sorry.
An instant felony.
Yeah, right. It's a good question. I don't think so, but not having looked into it, I hate to say for sure, and then like have given you the wrong answer. So let me take a peek at that, but I'm not sure. I don't think so off the top of my head, or at least I can't think about it.
So this would be something very new to come out statute.
If there isn't something else.
Yeah.
Right. Yeah. So that was pretty straightforward to explain, but I can pause again if there's any other questions.
We have questions?
I was gonna say, we did do something, we did change the law to say that with retail theft, you can aggregate. So no single item might be over 900, but you could, if you aggregate the total and it's over 900, it's a felony.
Yeah, that's true. Yep. Similar sort of, not based on the particular property, but yes, that's another approach that the legislature's taken to permit different factors to go into whether you cross the $900 line or not.
Even though I was one of the sponsors on that other bill to make it a felony to steal a firearm. Why wouldn't it be included anyway, since it would have a value? Oh, it's under 900 we're going for. Okay, I'm sure. It's been a while since.
Oh, I love those kind of questions where the person answers it themselves.
Softball question.
Yeah, I appreciate that. Thank you, Representative.
And I also have a question on the 10 years and the 5,000.
Yeah,
Are those in line with other statutes or?
yes, for the property felonies. Yeah. All right, shall we move on? Okay, all right, so moving on to section 2, it starts at the very bottom of page 1 and goes over onto the top of page 2. Now we're dealing in particular with persons prohibited from possessing firearms, and in particular, people who have been convicted of violent crimes. So every state, all 50 states, Vermont included, and the federal government have these sorts of statutes on the books. And these sorts of statutes prohibit possession of firearms by people who have been convicted of certain crimes. So every state has that, the feds have it. Vermont's, which you're looking at right now, was passed in 2015, happens to use the term, you'll see violent crime. It's on the bottom of page 1, and then we're going to turn over to page 2. And the general prohibition is that the person has been convicted of a violent crime, then they are prohibited from possessing a firearm. And the statute defines violent crime, and starts on page 3. And this isn't changed in the bill, but I'm just referencing it for the committee that the definition is there. Doesn't include all felonies. It's a specified carve out of certain felonies. And as I say, this Vermont version of this, what sometimes is referred to, not always exactly accurately, but sort of colloquially referred to as felons in possession statutes. That's what these are often referred to as, even though they aren't all felonies, and they sometimes aren't felonies themselves. But for purposes of the Vermont statute, violent crime is what's used, and that's the term that's defined. So what's the proposal to change that in this bill? That's in page 2. Actually, it appears a couple of times, but the first instance is on page 2. The current penalty for a person who violates a statute. So in other words, you've been convicted of one of the violent crimes and you possess a firearm. So that would be a violation of the statute. What's the penalty for that? Currently, it's a 2-year misdemeanor. That is on page 2, lines 4 to 5. 2-year misdemeanor, $1,000 fine. So the proposal is to keep that penalty for a first offense. But if it's a second or subsequent offense, then it becomes a 3-year felony, $5,000 fine. And that is on lines 6 to 7. That makes it understand how that proposal works. It's to, and again, this make sure I'm correct to see this. Yeah, this section is also unchanged between this amendment and the bill as introduced. So it's basically for person convicted of a violent crime to possess a firearm currently illegal, but its proposal is to change the penalty so that first offense remains the same penalty as existing law, 2-year misdemeanor, but second or subsequent becomes a 3-year felony. All right, I can move on unless there's any questions on that section. All right, now we're moving on to section 3, which is over on page 5. Now, what I just was talking about is the category of persons who are prohibited from possessing firearms based on conviction of certain crime, right? As I said, sometimes called felons in possession, Vermont, conviction of a violent crime. There are also other categories. In addition to the being convicted of certain crimes, there's other categories of persons who are prohibited from firearms possession, both under laws in all the states, under federal law and under Vermont law, and they are in a separate section. In other words, this violent crimes conviction is one section of law, and then there's this other section of law right next to that section. Yes. And that is being amended, proposed to be amended on page 5. And as I say, these other categories of people, which you start on page 5, and this is existing law, you see 1, 2, 3, and then there's number 4 over on page 6. Those are all based on federal law. Federal law actually has, I can send, if anybody's ever interested in this, it happens to be 18 USC 922G, which is the list of other people under federal law who are prohibited from firearms possession. The very first one is the convicted of crime punishable by a term exceeding 1 year, which is the federal version of what we just looked at. Fugitives from justice, unlawful users of substances, certain substances, et cetera, et cetera. So that's the federal list. A few years ago, only 2 years ago now, 2023, the legislature passed this statute that you're looking at, 417A, to add a couple of those categories that are in federal law already to have those persons prohibited under state law as well. Everybody with me so far? So these categories, those 4 that you're looking at, existing law, bottom page 5, fugitive from justice, subject of a final relief from abuse order, that's number 2. Subject of a final order against stalking, number 3, over onto page 6. Person against whom charges are pending for, and then it lists 3 particular offenses. Those are all people who are also already prohibited under federal law. Although, just under page 6, line 1 there, federal law uses the term under indictment, not against whom charges are pending, but same idea and extra, yeah, I'll leave it at that.
Can we take it a little bit deeper,
Yeah,
paragraph by paragraph
yeah.
or something?
And with the one.
Well, I mean, starting on like page 2, we're already up to page 6. It was gone over a lot on time.
Yes. Now, none of that is changed, but I
Right,
can certainly
but
talk about whatever you want to hear about. Absolutely.
It's not printed black and white in my brain from the previous time we've done it. So,
I know, it has been a little while.
yeah, I'm not saying, like convicted of violent crimes.
Yep.
I'd like to go through those
Yep.
crimes. So,
Yeah. That's another document I can send you and have posted as
Oh,
well,
okay, that's
if that
fine.
would be helpful. But for the most part, the violent crime, because I remember how that list was created. It was in the Senate Judiciary Committee, many, many days of testimony going through each of the crimes in the list of listed crimes, one by one. Do we want this to be a crime that prohibits a person possessing firearms? Yes or no? And we got through that entire list of listed crimes, and you'll see page 3, line 16, 17. Violent crime means a listed crime as defined in 53017, other than. And that's because those exceptions were made during the course of that discussion. Committee went through every crime that was on the listed crime list. Do we want this to be prohibition or not? And when they came to say, no, we don't want to include that, that got into this exception list. See what I mean? And then there was a couple other, if you got to in addition to the listed crimes, there are over on page 4, subdivisions B, C, and D. Some other testimony I specifically remember, the Center for Crime Victims on B, the State's Attorneys Association on C and D. They said, we want these to be included as well because they aren't listed crimes. So they also want to include sexual exploitation of children and certain drug offenses. And that's
Yep.
sort of the genesis of that. I'm surprised I can remember that so clearly.
So, I was gonna follow up, or I was gonna bring up the same thing
Yeah.
that Rep. Oliver did, but, wouldn't it be beneficial if there's somehow or another we could get those lists of crimes to us now so we could follow up on that? How long ago did we go over those crimes? Because we've
Yeah.
done so many of gun bills since I've been in this building.
You mean when did that
Yeah.
get created? That was, hang on, I just have that, I thought I had that written. Thought I'd written that down. I think it's 2015. But anyway, I do have the list and a separate document I can definitely have posted and sent to you so you can see the list in addition to it being right there in the bill. But I'm pretty sure that statute, 13 BSA 4017, was passed in 2015. So
So we're
roughly
looking
10
at-
years ago,
What's that?
roughly 10 years ago.
Maybe going on 11, but,
Right.
we're trying to, rush this bill through kind of fast, not kind of, we are, or we're trying. And, I want to know exactly what I'm doing and what I'm talking about, number one. And number two, if we could just back up, there's probably a lot of people, around here and maybe listening that, what's a starter gun? On line 12 on page 2. What's that listed as?
Oh, this is the, just so you know where that definition comes from, that's the federal law definition of a firearm. So that's where that language comes from. So as far as I think it's sort of what you would think of as sort of plain language kind of thing. I think of a starter gun as, maybe because I'm an official in swim meets, but I think of the gun sometimes in swim meet as a starter gun. But as far as a legal definition goes, I don't know if that's correct off the top of my head, but I can certainly look that up. But I will say that where that language comes from, that's the federal firearms definition.
I think I recall that discussion, as well. Being, a track coach and official, we use that, I mean, in all of our activities. So very similar to, all of the athletic starting pieces, and it's use of a fake but pretty accurate looking firearm. If somebody puts that in your face, you're gonna, look pretty closely, at it, because it's really hard to discern. But I remember that discussion back then, believe it or not.
Thank you.
I just want to make sure that, Ken, you're done.
Yes, thank you.
Following up on Representative Ghostknight's question about starter gun, the word that I'm kind of curious about, and I'm on page 3, line 5, is rimfire and conventional centerfire fixed ammunition. And I realize that this may be derived from the federal statute.
Yes.
But I think it would be helpful because, even if you go back to line 17 on page 2, we have a very distinct definition for anti-firearm.
Right.
And I'm curious because, just doing some cursory research in the lead up to this bill, rimfire, from my understanding, can be defined several different ways. And so I do think it'd be helpful if we just kind of dive into the granularities of what we're actually talking about.
Yeah, again, I suspect because that antique firearm definition is exactly based on but also exactly what's in federal law.
Sure.
So I'm just without having researched it, I would speculate that those terms probably have been fleshed out in some federal case law because of the fact that this has been around for a long time under federal law. But in terms of a practical definition of it, I would suspect that you might have witnesses other than myself who would be able to give you a more hands-on, so to speak, definition of what those terms. I should point out there though, too, it's interesting, if everyone sort of picked this up, for the reason for focusing in on that language, why it's important, is that those types of weapons are excluded from the definition of firearms. So in other words, they would not be, a person could prohibit those and it would not be unlawful.
Possess.
Did you follow that? So I thought, no.
Prohibit.
Possess.
Yes, thank you. Yes, person could possess those without violating the statute because it's in a carved out exception. Alrighty, are we okay on being in section 3? Which is, as I mentioned, this list of other categories. We're getting to some of the other categories now. There's a few that were passed in 2023 that we brought us over to page 6. And so what's the proposal here then with respect to these other categories, other than persons who have been convicted of certain criminal offenses? 2 pieces to this proposal. I'm kind of going to go back in order of reverse order, because the second one is much simpler. That's over on page 7. That's just the same thing that we looked at already with respect to the criminal offenses. In other words, making, instead of having all violations be a 2-year misdemeanor, a first violation will remain the same as that penalty, 2-year misdemeanor. But second or subsequence would be the 3-year 5,000, and that's on page 7, lines 2 through 5. Everybody see that? So that's the same principle that you looked at with respect to the persons convicted of violent crime. So that's one thing that's done with this other category of what's often referred to as prohibited persons. Right? What's the other thing that's done with respect to prohibited persons? That is on page 6. Again, this is a category of people, just like the first 4 in the existing statute. This is a category of persons who are currently prohibited from possessing firearms under federal law. However, this proposal is to add a comparable provision in Vermont law. And the reason I didn't say that it's identical is because it's not identical in the sense that the federal law prohibits a much wider range of people, a broader group of people than the proposal here. The proposal here is to prohibit only a subsection of, or a subset is a better way to put it, a subset of the people who are prohibited under federal law for mental health reasons is what this is all about, from possessing fire. So within this category of people, because of court actions that have taken place in their history on the basis of their mental health status, there's a category of those folks who are prohibited from possessing firearms under federal law permanently. Right? That's an important point, because that's one way in which this proposal you're looking at is different than federal law, because it's not all permanent. It'd be helpful for a second, I think, to look at, because you'll see and I should mention too, that you may already know this, that this language, the specifics of this language I worked on this draft and she authorized me to mention it to you with Representative Donahue. So that's where this particular subset proposal comes from. But just for a moment, look at page 5, line 17 and line 19. These are the 2 other existing subdivisions of categories. And you see the way that there's a written there. Number 2 is the subject of a final relief order issued pursuant to Title 15. And number 3 is the subject of a final order against stalking, etc. The point I'm making there is you see the way that's phrased, is the subject of. In other words, once the order expires, they're no longer prohibited. That's they have to be the current subject of this order. So for example, the RFA order, number 2, once the order expires, they're not prohibited from possessing it. They're only prohibited while the order is in effect.
Right, that's existing.
That's existing law. Yeah, I just wanted you to sort of see that, because that's kind of a parallel to what Representative Donahue was going for with these mental health orders. So if you look at page 6, for example, the 2 line 14 and line 16, page 6, because there's 3 different groups here, and I'm just going to start with the second, number 2 and number 3. Subdivision B is the subject of a commitment order issued by the court pursuant to section 4822. That happens to be the section which you will likely look at later in the year, because it has to do with a person found incompetent to stand trial or not guilty by reason of insanity. That's currently being worked on in the Senate in the context of the forensic bill, which gives me a nice segue to say I have to be there at 10:15. So that's how far I can go on this. But where was it? Oh yeah. So and same thing with subdivision C there. is the subject of a hospitalization order issued by the court pursuant to 8. And that citation, that's the civil commitment statute. That's not the criminal, that's not the forensic people that are coming into the Department of Mental Health custody on the basis of having come from the criminal division, hence the word forensic. Those are people that are coming in because of a petition in the family division of the Superior Court. Whereas under current law, an interested party can go to the family division and file a petition. If the court finds that the person is a danger to themselves or others on the basis of a mental illness, that person can be committed. So under federal law, if you've ever had that happen to you, you're prohibited from possessing firearms, permanent, right? So you see how this is different. It's based on the same language we just looked at with respect to RFAs and stalking laws. Is the subject of it. Representative Donahue's point there was, shouldn't this person be able to possess when the order is no longer in effect? And that's why the language is phrased that way. Is the subject of a commitment order, is the subject of a hospitalization order. So once that person, if they're the subject of, they will for a while be in DMH custody, possibly on an order of hospitalization, possibly on an order of non-hospitalization. But when that order expires or when DMH takes action to end it, which they do sometimes, then they wouldn't be a prohibited person anymore. That's the concept. So different, as I say, that's a smaller group of people than are prohibited under federal law. Once that prohibition attaches, sticks with you. All right, so there's an exception to that in Representative Donahue's proposal, and that's in subdivision A. She's trying to get parity for persons with mental health reasons and persons who are not. And she said, but on the other hand, if the person has been found, I'm looking at line 10 now, not guilty by reason of insanity for a violent crime. Well, remember, not NGRI, not guilty by reason of insanity verdict happens, the person has been convicted already. They've been convicted of the crime. It's just that the court or they are able to prove as a defense that, well, I may have done it, but I was insane at the time. Therefore, I shouldn't be convicted. But the conviction is still there. So Rep. Donahue's point was, well, that person, they were convicted of a violent crime, which, as we just saw in the preceding section, does prohibit a person permanently from possessing a firearm. So she said, with respect to that group, okay to have them be prohibited permanently, because that's the same way a person without a mental illness would be treated.
Thanks, Chair. Eric, I'm curious if Representative Donahue, when she walked you through this, because here's the thing, right? If someone is under a hospitalization order, and I'm just saying hypothetically, if they were diagnosed with bipolar or schizophrenia or something,
Yep.
The hospitalization order might be lifted, but the mental illness still persists. So if the mental illness still is in existence within this person, should they have access to a firearm?
That's a fair question. And as a non-medical person, I would defer. I think she has more knowledge of that than I. So to respond to your question, we didn't get into the granular details that you just sort of raised of that very interesting policy question. But it'd be a worthwhile one to ask.
Well, and I'm just kind of curious because it also doubles back to how we can provide a carve out to federal law. Because we have very fierce debates in this room about, really where the extent of our authority lies and what that line is,
right,
as it relates to federal oversight.
Yeah.
And it seems like this might be beyond that.
Well, it may be a different way to think of it is because it's not a carve out to federal law in the sense that those folks would still be prohibited by federal law from possessing a firearm. But what you're saying is, or I should say, what you would be saying if you pass this proposal is that group of people, in other words, the people against whom that order is no longer in effect, would not be able to be prosecuted in a Vermont state court by a Vermont state's attorney because it wouldn't be legal under Vermont law. In order for that person to be prosecuted for that offense, it would have to be a U.S. attorney in federal court because it would only be a federal offense, which the legislature sometimes does, but that's a policy call for you guys as to whether you think it's appropriate or maybe you think that the federal policy is a better one, which is also a legitimate way to land.
Yeah, I find it strange because typically the policies that come out of this committee, we don't really find leniency when it comes to federal crimes. So I'm just curious why this was an exception. I know that's not for you, but that's just
right. Yeah, sure.
So if somebody I'm just a little confused on how this mental health piece works.
Yep.
So if somebody has a situation, an event, whatever you want to call it, ends up in the hospital, it is deemed at some point to have a mental health issue, I guess you could say, but then they're released and deemed, lack of a better word, healthy again. How does federal law treat them at that point, and how does state law treat them at this point now? And does that change with this bill?
Well, just to sort of reframe your hypo a little bit, because a person who just ends up in the hospital for treatment isn't necessarily going to be covered by the federal law or the state law. These only apply when someone is involuntarily committed. See that? Doesn't even apply. It doesn't even apply. Federal law specifically says it doesn't apply for voluntary admissions.
Okay, so
It has to be an court ordering you to be committed.
right.
Yeah.
So if they're involuntary committed and they go through their treatment and they're deemed healthy
Right.
again.
Yep.
So what happens?
Yes. In that case, let's say in that case, that person would have been committed to the Department of Mental Health custody, even if they stayed in the hospital, because DMH has a number of hospitals they use around the state for these sorts of involuntary mental health commitments. That's the case, but they clinically decide later on the person can be released. Then what would happen under federal law, under existing federal law, is that person would still be prohibited from possessing a firearm because that attaches permanent if they've ever been involuntarily committed. However, now I should add that this will perhaps be deja vu for the committee a little bit. There is a process under federal law known as where you can get your firearms rights restored. And committee may remember when we were talking about the animal cruelty bill, that we put a provision in the animal cruelty bill that I said to you was based on this other provision from firearms law in the state that allowed a person who had been prohibited from, working with, owning animals in the future to petition the court for an order that they could have their rights restored. Everybody kind of remember that? Well, that was based on this similar provision in firearms. The only reason I mention it, Representative Burdick, is because when I say that prohibition is permanent, there is that option for the person to go to court and say, hey, I shouldn't have my firearms rights prohibited anymore. Maybe I've had mental health restored for a long period of time, whatever factors they might use to make that argument. So that just sort of, so you have a full understanding of what that's out there. But other than that, let's say the person hasn't done that, then yeah, they would be prohibited under state law. Interestingly, you don't have anything on this in state law currently. So in other words, under state law, that wouldn't be a crime.
My next question was going to be, as far as the federal law goes, has it been challenged? But I'm wondering if you could challenge it, since there is a way to petition to get your rights back.
I think there has still been litigation on the subject of under what circumstances a person, whether it's an infringement on someone's firearms rights for them to be permanently barred on the basis of certain types of involuntary commitments. But I don't think that the Supreme Court has looked at the issue.
Right. I guess kind of where I'm going with it is, we debated this a number of years ago in here. And it was a mental health piece, and member from Middlebury, I remember once somebody was deemed healthy, I remember there was a piece that somebody wanted to add to the bill that they still couldn't get possess or own or buy a firearm for another 30 days. But we came to the conclusion in the committee that once somebody was deemed healthy, that how can you restrict their rights when there's, in a sense, nothing wrong with them?
Right.
And this kind of steps on that. But right, wrong, or otherwise, this is something this committee has already debated. They came to a conclusion on, and now we're changing it again.
Well, I think under current law, there isn't any prohibition in the current law. You may be thinking of though, the reporting requirement. There is a reporting requirement in current law so that if someone has been involuntarily committed, then those names have to be reported to the National Instant Criminal Background Check. So in other words, even though it's not a state law prohibition, they do have to send the names of them so the feds can put them in the national prohibited person list. And that's probably, I bet you, where that discussion you're remembering
Maybe
came
we
up.
were discussing voluntary.
Yeah, I bet, yeah. Yep.
Talking back, you know, since we're probably 15, 16 biennium.
Yeah, I'll bet you're right, because the reporting law that requires the names of those folks to be reported to NICS does apply to persons who have been found a danger to themselves or others as a result of a mental illness and been committed.
Yeah, because if we were discussing involuntary, it would have come up. That
Yeah, right. Yeah.
goes back to the federal law.
Yep. Well, interestingly, this, and this is specifically what Representative Donahue was trying to do. This doesn't prohibit that universe of people from possessing. Because this says is subject to, generally speaking. So if the order goes away, you can possess.
Oh, okay.
And that was Representative Harvey's point, which is, you know, if a person still has, even if it's in remission, so to speak, the mental illness, is that the way you want to go or not? So,
Someone can go into remission for mental illness, right?
yes, what's the word I'm looking for
Yeah.
though? It's with respect to competency. Oh, restored. Some competency can be restored, but then they can become incompetent again. Right. Yes.
Fugitive from justice, and the person who's fled to avoid crime, to avoid giving testimony in a criminal proceeding.
Yep.
Or to avoid. With that.
Are you on page 5, I
I'm on
think, right?
7. Looking, just that,
Fugitive, yeah, I see it, right?
I jumped up to that to find that
No,
definition, but
Yep.
would that include somebody who's got a simple jaywalking bench warrant in another state or fishing violation that's showing up as a misdemeanor warrant?
I would generally view a misdemeanor as I think that is a crime. So if it's I don't know if it's in another state, could be a civil offense, that would be
Could be a
excluded.
misdemeanor too. I
Right.
mean, in Vermont, it's a civil, but
Right.
in some states, they're misdemeanors. And that seems like sort of a unfair blend.
Right. Yeah, I think as long as it's a crime, which does include a misdemeanor, then it would be covered. But it could be, there could be the potential where, like, let's say if something were a civil offense in another state, then that could be something that a defense lawyer would raise, like, hey, this isn't a crime, they shouldn't be prohibited.
Here, it might be a civil offense, but in another state, it might be.
Oh, I see what you mean, right, the opposite. Yeah, right. Yep. Great. All right. Are we,
Are you looking to change that?
I don't think it's really fair. If it's a civil offense here and it's not
Right.
excluded, and it's a misdemeanor in another state, you could be excluded by having an unresolved violation in another state that's could be a misdemeanor, but petty. And it's not a listed offense that would normally stop you from getting one.
Right. So you're looking
I
at
guess that's my point.
some language that it would have to be a crime here.
Well, you're assumed to be a fugitive if you leave the state and have an unresolved issue, but you're not fleeing. I mean, that's
Right, we could be looking at some pretty petty stuff.
right, but it's still gonna show up in a criminal record. And it may not be a misdemeanor in the state of Vermont. It might be a civil violation. And Fish and Wildlife are often a blend. Right? Fish and wildlife violations are generally
so, yeah, some are civil, and some are misdemeanors, yep, exactly.
all done on a ticket.
Right,
So if you have an unpaid ticket in another state, that might be a misdemeanor. It could be a civil violation here, but it'll show up in NICS. Who decides if it's a fugitive or not?
Well, if it got litigated, it would be up to the court. But you're right that if you wanted to limit it in that way, you could conceivably put in on line 9, for example, prosecution for a Vermont criminal offense. You want to kind of avoid that disparity.
Future confusion.
Or we could say for an offense that would be a crime in Vermont.
Yep.
It'd still be, it would, if it's a misdemeanor elsewhere, but would be civil offense here. So that's all I
Well,
want.
wouldn't you then make it, one of our listed offenses? Or just anything? 'Cause you could have a warrant for something and still, be in litigation for something theoretically that's not like a domestic, still be able to buy a firearm. You may not have a warrant, but you're not a fugitive because you're in state. Well, could be. Yeah. you could-
Yeah, I think whether you want to do it or not is possible.
Yeah,
Yeah, I think the idea is the MIA person, not so much what the offense is. It's like, are they trying to get away from it?
so then they can only resolve it to be reinstated.
Right.
Yeah.
So the federal language on that one, for example, is a fugitive from justice, also similar. But
Well, let's try out the for an offense that is a crime in Vermont.
okay. All right, shall we move on to, I think, the final section? Section 4? All right, so section 4, as now you have this is make an amendment to a current statute that was passed in 2017. So 13 VSA 4022 passed in 2017, the prohibition on bumpfire stocks. And you see that definition in existing law is lines 14 to 18 on page 7. So the proposal here is to add 2 other devices to the current bumpfire stock prohibition. These are also devices that involve increasing the rate of fire of a firearm. And these 2 devices specifically are auto sears is the first one, which is the bottom of page 7. This is based on the federal definition, ATF, Bureau of Alcohol, Tobacco, Firearms, and Explosives. They issued a ruling a couple of years back about auto sears, saying they were covered by the federal machine gun definition. And I'm just reading to you from this ATF ruling that the auto sear is a combination of parts designed and intended for use in converting a weapon to shoot automatically more than one shot without manual reloading by a single function of the trigger. So you see that very similar to the language that you see in subdivision 2 there. That's what it was based on, means a device other than a bump stock, because that's what it covered, designed to convert a semi-automatic firearm to shoot more than one shot with a single pull of the trigger without manual reloading. I should also point out there that definition in ATF's ruling was also referred to approvingly in the United States Supreme Court decision a couple of years ago. Also both referred to that ruling and reiterated the decision on the language used by the Supreme Court. And that decision was that an auto sear permits a shooter to fire multiple shots while engaging the trigger only once. ATF has accordingly recognized that modifying a semi-automatic rifle or handgun with an auto sear converts it into a machine gun. So that was what the Supreme Court noted 2 years ago. And so those concepts, what's the case? Oh, yeah. The case is Garland v. Cargill, CARGIL, June 2024.
Thank you.
Yep. So that's where the language comes from. And the language is fairly straightforward as to what it's intended to cover. Again, I think at least by the current interpretation of ATF and the Supreme Court's decision also already covered, but again, making it a Vermont offense here. So that's number 1. Number two, that's over on page 8. And here, we're talking about a separate kind of device. I should say different kind of device, but has a similar effect that you'll see. So this means any device, including an autoseer, and I'm on line 1, page 8. That when installed in or attached to a firearm increases the weapon's rate of fire or the rate at which the trigger is activated. And it's the term that is proposed to be defined as is rapid fire device. And there's a number of states. Oh, I should have mentioned. Sorry, I meant to mention that on the auto series that there's a plus or minus 25 states that also have a prohibition on auto series. Rapid fire devices is another type of component that some states also regulate. They often, it's hard to find a commonly used terminology that crosses all states. So that's why it's a little bit harder to say, oh, well, this number of states prohibits this already. You know, it's in the neighborhood of 10 to 12 to 15, possibly between 10 and 15 who do this kind of thing. And it's a, as you can tell from the language, it's a definition that, or sorry, a device that increases the weapon's rate of fire or the rate at which the trigger is activated, but it doesn't do the same thing as an autoseer, because remember that specifically allows the weapon to be fired with only one depression of the trigger without manual reload. So this could actually increase the rate of fire, but still you have to either mechanically assisted or otherwise press the trigger more than once, essentially.
Back of the top.
I'm just wondering where the rapid fire language came from.
Oh, yes, Maryland. Yes, that's from Maryland statute. They defined it as a rapid fire activator, as opposed to device. Other states use the term rapid fire device, rightly or wrongly. I like rapid fire device better. So as a term, I chose that even though I use the Maryland definitional language. But as I say, a few other states that use, and if you looked at some of these states, and I'd be happy to send you this too, you know, you can look at, there's some languages very similar, some different, but I was trying to kind of use some language that was out there already as opposed to trying to make it up.
Thank you.
Yep.
So rapid fire device doesn't necessarily mean pulling the trigger once and.
Correct. But it could be a device that helps you or aids in the speed at which the weapon fires, even though you're in one sense or another pulling the trigger more than once, or either by assistance or maybe you have a device that allows you to do it. And again, I'm certain
Device?
of some kind. Yeah, some kind.
A device?
You mean your own finger?
Yep.
No.
You can rapid fire with it.
Oh, I think if you're just really good at it, I don't think that would cover this.
If you lessen the pressure, the amount of pressure it takes to fire a gun with the trigger, you can if you hold your finger just right on a trigger that's sensitive, it'll rapid fire.
Without the addition of some other mechanical device to help you, you mean? Just because, then I would view that as not covered. If you just happen to be a skilled
Okay.
person, that's because it's not a device.
Skill.
Yeah, I would say not covered.
Okay.
But again, I'm going to bet that you have other witnesses who can give you some more time.
Right.
These things work.
I got a question for the committee. What's an auto sear? How's it work?
I think we have witnesses that can testify.
No, well, we got committee members supporting this. I'm not saying I support it or not, but.
I think that we can have discussion later. Let's hear from witnesses.
Yeah, by then people are gonna go online and figure out what it is. How they work, because I question how many people in here know how a clock switch works.
Well, I mean, I can tell you that the reason that I put this into the bill as originally introduced is that I received a letter from Glock.
No, and I realize all that, but that doesn't show how exactly a block switch works, other than the definition that it makes a gun shoot fast.
Yeah, I guess I don't understand.
Well, what's a block switch? What's it do to the firearm other than make it?
It makes it essentially an automatic weapon.
Oh,
I don't think I need to know that to understand that I received from, at this point, that's why I have testimony on this.
So they go on the
From
trigger?
experts. That's my understanding.
people don't know if it goes on the trigger, on the barrel.
No, I just said, but and again, I think we're gonna hear from witnesses.
No, I know, but that's just information that people, we're putting this in a bill. And my guess is an advocate came to somebody originally way back when and said, block switch bad, we better put it in the bill and make it illegal. And people don't even know what they are and what they do, other than they make a gun rapid fire. They don't know where it goes in the gun, what it
No.
does to the gun.
Tom?
So just a second, Coach. So again, the way bills work is you can listen to me, but
Don't patronize me.
well, you're kind of patronizing me with that question. The way, is.
You can't answer it, is my point.
I can answer by going back and looking at the letter I got from Glock, and I understood it at the time. Do I remember what exactly the mechanical device is for that? And I don't think that is relevant to putting this into a bill and hearing testimony, including individuals who are experts on this. So I mean, I find that question to be really
Well,
odd.
I think it's very relevant because there's, things that have happened in the past about people, wanting to outlaw semi-automatic firearms because they think they're automatic. And there's just no comparison at all. And
Agreed.
because people talk about things that they don't know what they're talking about. And that's kind of the way I look at this, is this is in this bill and people don't really understand what a Glock switch is.
I think it was sufficient understanding to have this put into the bill and put it through.
I'm not saying it's right, wrong, or otherwise. I'm just saying that
All right, I understand your point, but let's proceed with some additional testimony, unless there's any questions for Eric. Any additional questions? Yeah, Ken.
So, just sticking on the Donahue stuff,
Right,
not the mental health quite yet,
right.
but I do know part of this was the stealing of a firearm that happened in Berlin. I know that situation fairly well. As one of our constituents.
Oh,
And the house was being worked on. One of the workers, they had to get in and out of the house. One of the workers that was supposed to be trustworthy decided to go through the house, stole a very important firearm to pay off for other things that were needed money for. It was finally basically, as usual, a plea deal is made and found. We plead way down the people that we really want to keep weapons away from, not innocent people that can have a firearm. The deal got plead down, I believe. He basically got away with nothing, a little slap on the hand, as I frequently have brought to my attention. And very light sentence, if I remember, was out. And I think did another crime and basically another plea deal. The same thing is what we're constantly hearing about, especially in this committee. It's what do they call it? The catch and release program. And then they just continue on and on and on, which leads me to the mental health part that Representative Donahue is bringing up in a different capacity, but still these people, a lot of the people that are doing it need the help with the mental health part, but we're not we're not fixing that. We're not dealing with that. That's one of our main priorities of doing that. And then the innocent people that want to carry a firearm, be responsible, protection, whatever, their rights are being imposed on. And I don't know. Do you have any ideas how we fix that? You are the lawyer, by the way. I'm just Kenny sitting here. I'm just.
Yeah, that's probably a broader question I can answer right now, but whatever ideas any of you guys have, I'd be happy to draft those for you. I will come those and tell you how they might work.
I can't wait.
Yeah, right.
Yeah.
Eric, just a quick question, because as a freshman legislator, I'm new to the discussions around these type of bills.
Okay. Great.
I don't know if were you around for the first, for 4022, the bump stock?
Yes, yep.
Was there any discussion at that time around adding that section into the possession of a firearm while committing a felony? Like as like an aggravating factor or like as a separate offense?
Adding what? Say it again, sorry.
So in the same section in 13, I think it's 13 BSA 4005 is the crime when you possessing a
Firearm while you're committing a felony, right? Yeah. Okay.
So it doesn't really specify, like, it isn't just a firearm.
Right.
I was wondering at the time we were talking about bump stocks, was there any discussion around like it being a different crime if you possess a firearm that had a bump stock?
Oh, I see
while
what you
you're
mean.
committing a felony.
I don't recall that. That's again, my memory of things that far back is somewhat random.
Yeah.
But so it could have happened, but I don't recall that.
Okay. Thanks.
Any other questions for Eric? All right, seeing none, and you get to go.
Timing is perfect. I have to go down to Senate Judiciary. Yep, exactly.
We'll hear from Kim McManus and then we'll take a break. The other two witnesses had to leave at 10. We'll see if we can fit them in another time, but Kim, yeah, if you could go grab Kim. Yeah, that's so smooth.
Eric,
Yeah, sorry.
it's just downstairs and you got plenty of time to get there.
Oh, thanks. Right. I appreciate that. But I have to kind of bone up before I get there. It's a full different time.
More coffee or anything?
Yeah.
Anyone over there want to open the window? I would do it, but it would take more. Let's see. Kim's. It's coming.
Kim will be here momentarily.
You don't want to take a chance on a quick break now?
No, I just did, want to start with Chris, okay, great, or Matt Larry if he gets here.
Is she coming on?
No, she's right outside the door. Want to go grab her and drag her in?
Yeah, sure, well, on the way by.
What's that? I don't mean literally, I meant figuratively, of course.
Well, yeah.
Right. Thanks. We'll catch up.
Thank you, Eric.
Thank you, Eric.
Thank you,
Take care.
Eric.
Yeah, we'll see you.
Hey, thanks for being here.
Hello. Yay. Morning. Morning.
Hello. All right. Can I just jump in?
Yeah.
Okay. Good morning, everyone. Kim McManus with the Department of State's Attorneys and Sheriffs. Thank you for having us in for H606. We are greatly appreciative of the sections of the bill that we have proposed to the committee. As you might remember, our 10 priorities at the beginning of the year. One of them was 2 firearms initiatives. One was adding the theft of a firearm to be a felony. which is in section 1, and our department supports that. The other was the changes to the person prohibited from carrying a firearm in section 3. So I know you all are tight on time and have a number of witnesses. So I will just briefly state that our department does not have a position on section 4, nor section 5 of the bill as introduced. I understand there's an amendment that removes section 5. And so are we speaking just to the amended bill?
Yeah.
Okay.
So section, purple section numbers stayed the same.
Yeah, and section 2, I think is what.
Okay, sorry, 1 second.
There's a draft 1.1.
I have it on my computer, just not printed out. Let me just double check my sections now. Okay. So starting from the top, section 1, grand larceny. Thank you so much. Again, our department supports that the stealing of a firearm is considered a felony. Section 2, persons prohibited. We had not suggested the second or subsequent offense, but we have no issue with that if that is the direction that the committee goes in. We do appreciate that when these are multiple offenses, it is quite frustrating to have to charge it the same way each time. So again, that was not something that we had put forward, but we have no issue with that. And we appreciate the reasoning behind it. Section.
Yeah, go ahead, Jack.
Kim, just a quick question on section 2.
Yes.
While we're there, I'm curious if the department has any statistics in terms of the number of how many cases have been charged or prosecuted related to these offenses in the state. Not to put you on the spot. You can always
Yeah, that is definitely a number that I have in my mind. But that is something I could get you some rough.
Yeah, just a rough estimate.
And what sort of time period?
Well, I
Past
think
few
the
years?
chair.
30?
Yeah. No, I was like, yeah.
I
Time period, say like the last 5 years.
Okay.
Yeah. Because I'm trying to capture the COVID era as well. So maybe 6 years. Let's go back to 2020.
Charging the prohibited.
Yeah, I'm just curious.
I know I personally have charged it. So.
Yeah. Yeah, but I'm just curious if is this something that's super prevalent? Is there 5 cases a year? Is there 100 cases in the state? Has it increased? Has it decreased in frequency? I'm just curious.
Okay, I'll be able to get raw
Yeah, perfect.
information for you. I probably won't be able to analyze it, but I'll let
That's fine.
you.
Thank you. I can analyze it.
How do you feel about language in there saying, instead of constructive knowingly?
Where are you, Tom? Can you,
In grand larceny, 2501A.
is that in section 1?
Yeah.
Can you tell which line, just so I follow?
Well, I'm thinking out of line 7, line 8, probably line 7. Does constructive possession. I'm thinking more along the lines of knowingly.
Well, this is historically our language around theft, using the actual or constructive possession. So it would be a choice if for the firearms piece, you wanted to change that. To have
But that
another
is your
piece.
comment. That's,
Yes, that's as for any theft of any object, that actual, or that it's the possession of stealing that. Section 3, and now I'm just double checking that my notes line up with the amendment. Yes. Okay. So the language that was in the original introduced bill is the language that our department supports. The language that is to have been found by a court to be a person in need of treatment pursuant to section 4822 or the subject of a hospitalization order or non-hospitalization order. The amendment, the amended language, we would be concerned. Let's put it this way. This would get us partially to our goal. It would leave out a number of persons who we would be very concerned about having a weapon. So I think this unfortunately carves out a lot of the scenarios that we were contemplating when we suggested the language that was in the as introduced bill. So we would be opposed to the amendment. We would ask you to reconsider going back to the proposed language, and with the particular focus that the proposed language had the ability for a person to go to the family division to ask for a petition for relief from, if there had been previous findings. So there was an ability for a person to go back, be able to get their legal right to own a firearm, depending on their situation. So we would ask, we think that's simpler, cleaner language. And again, it aligns with the federal language. And that would be where we would want this committee to focus on. And then again, on section 4, we do not have a position.
Any questions for Kim? Quick time.
Kim, with you don't have a position in section 4, you said.
We do not.
Maybe you can still answer my question. So making this, it's already illegal federally, which that is what it is. So if somebody did get caught with, with these devices or this device, how likely, in essence, you have a machine gun, in essence, I guess. They're not real life. How likely is it that the feds would prosecute that other than the state?
And stop. The likelihood, it really depends on what ATF has going on. When these cases that would, it could be charged either by state or federal, it's a conversation with our federal partners that we would reach out, say, hey, we have this case, do you want it? And then it's their choice of whether they take that on. And then, of course, they have their own separate investigations as well. So it's hard to say the likelihood.
Yeah, I didn't know if.
It really depends on what they have going on and what their
Sure.
priorities are.
Yeah, I didn't know if, when it was something, of this magnitude, where it was on their scale, I guess, as far as importance goes. But there's variables to be considered too.
Yes, you would need to ask someone from ATF or the U.S. Attorney's Office. It really varies when they want to get involved with which cases they want to get involved with.
Right. Any feds been asked to come in to testify on this?
Nope.
I'd kind of like to know the likelihood as far as that federal law goes, where they would stand as far as prosecuting those.
I doubt very much that the Fed prosecutor would tell us whether they would be likely to prosecute that or not. And I know in past firearms related bills, we've reached out to federal entities to testify. They've never agreed if they wanted to testify. So
Yeah, often the U.S. Attorney's Office will not be able to say, they can't project what they would prosecute or not. But again, I think part of it is, it depends on what they're being told to prioritize within their office as far as which crimes.
Right. And it's going through my mind is somebody goes into a bank with one of these is probably going to be a higher priority than somebody shooting in their backyard.
Right, or major drug related incident with a lot of firearms, right? That's very, the facts and circumstances would greatly matter as far as whether the federal agents would get involved.
Any other questions for Kim? All right, thank you, Kim. Not seeing the questions. We'll take a break until 10:30. We might have Matt Valerio and then Chris Bradley, depending on if Matt Valerio gets here, because he has some time constraint.